Good morning. Our next case is People versus Horton. This is a 15-minute mini oral argument on the application. You have 2 minutes of a free-fire zone, and you may reserve time for rebuttal, but we ask that you keep track of that.
I appreciate it. I'm going to reserve 5 minutes for rebuttal. Good morning. Obviously, we submitted briefs on this case, so for once, I'm not going to regurgitate them. I'm just going to give some very, very brief commentary. Obviously, the foundational rationale of the line of jail guard cases is to ensure the defendant is entitled to be brought before the court with the appearance, dignity, and self-respect of a free and innocent man. We've all read all the cases. I know we know that. And really, when you look at the cases in general, on one side of the spectrum, you have the well-established line of cases where we all know if you're brought before the jury with jail guard, we all know that. That's well-established case law. You can't do that. That's obvious. Then I think what you have sort of on the other line of the cases are the jail interviews where somebody typically is in custody in jail guard. They're typically being interviewed by the police, and generally that's been found to be acceptable, doesn't infringe on due process, doesn't violate any of the tenets of 403. So I think sort of foundationally that's where we sort of start this out. Those are, I guess you're going to say, the right and left end of the spectrum. I think what this case provides is this court provides the opportunity to this court, sort of post-COVID, to address a factual scenario that obviously the case law really hasn't addressed at this particular point. I really mentioned, well, why mention post-COVID? What does that have to do with anything? I think we're all aware now with the use of Zoom in court, and obviously video obviously is much more prevalent now, at least in my experience post-COVID. So I think when we look at using this particular video in this case, I think you have to sort of look at, well, now we have to look at is a video testimony here going to be construed differently by an average juror in 2023 with Zoom where it might be different if you go in the past. I think it is certainly different. Obviously, this case has the situation where my client is being viewed back and forth with the accuser in the case dozens of times wearing jail garb in open court. Then you really have to sort of juxtapose this with the fact that the accuser, you go back and forth. Because obviously the accuser here tragically is not going to be in court in this case because she untimely passed away. So the opportunity that the jury is going to have on looking at the defendant, at least in that jail card, is going to be focused intently.
Counsel, just a question.
Sure.
Good morning and welcome. Is there any way that, let's say this was sent back down to the trial court, is there any way that the testimony could be preserved? Like, for example, if you just did it as an auditorial, basically done it, as a tape without the visuals? Would that be?
Of course, and I pardon me for interrupting.
Of course, no problem.
I didn't mean to.
No, please.
Obviously, yes, and of course, let me make it clear. Obviously, this court's aware. I wasn't advocating that. Obviously, this should just be a transcript. That would be, frankly, disingenuous to this court, and frankly, a ridiculous argument. My thing was, obviously, that they don't see my client in jail garb. I certainly am not opposing a readback of the audio in any way or the transcript, but certainly that would not have any negative impact at all. So certainly, obviously, that could be done. And that's sort of what I'm asking, that the court shouldn't see the defendant in jail garb, especially in the CSC case.
Are you asking us to adopt a bright line rule that anytime the defendant is in jail garb,
No.
that can't be shown?
No, absolutely not. I think this case, as I said, is a different scenario. No, I don't think there should be a bright line rule because I don't think it would be consistent with the line of cases, federal cases, state cases. Absolutely not. I think here, obviously, the court has an opportunity. I don't think this is, as the prosecution stated, is going to open some type of floodgate. I think this is a unique circumstance where you have the accuser and the defendant in that video, and obviously the only opportunity for the jury to have it. So I think the court certainly has the ability to certainly narrowly tailor due process could be violated under this set of circumstances, and the court could certainly dictate parameters. of why in this case they think it's a due process violation. I don't think that means now that's it. We have to put everybody in civilian clothes. Not at all. I think the facts are very specific in this case. You have to understand he's in open court. I think that's a very important facet here that you can't ignore. And then obviously you have the 403 analysis.
Why does that matter?
Well, I think it matters because I think a reasonable juror is going to look at it differently. I think an average intelligent juror understands when people are arrested or in police custody and being interviewed. I mean, look, you probably heard the Law and Order many times scenario. Most people are interviewed by the police or in custody, and I think
The cases talk about that. Most jurors, you can rely on their common sense that the person who's before the court being charged with a crime probably at some earlier point in time was arrested and in police custody, right? How's that different than this scenario where they're given a preliminary examination at the beginning of the process?
Okay. Well, obviously, you're a learned juror that you understand the preliminary exam process. I think the average juror would simply look at the fact of being in court.
But we were going to have the helpful instruction, fairly detailed instruction by this trial judge explaining all of that to the jury, including that the defendant was only in custody at the very beginning and has been out on bond without incident for 22 months. And so where would the lay jury be then? They'd have all the information they need to understand exactly what happened in this case, would they?
Well, I agree. Well, I agree, certainly. I think the court was certainly well-intentioned with the curative instruction, but as the case is said, I guess why not simply do that on the line of cases if the person's brought in jail, he couldn't post bond, why don't we do a curative instruction for that? Why is the line of cases there? Because subliminally, it still sends a message, and I think
Made it very clear that it's much more prejudicial to have someone in jail garb live in person during the trial than at these earlier stages during a police interview or preliminary exam testimony, for example. So that's the level of prejudice. All of the cases that you've mentioned, all of them hold the same way. This case, if we hold in your favor, we would be the only court in the land to ever so hold. Is that not true?
Well, I think at this point, I don't think they've decided against it. I don't think there's been a factual scenario that's similar to this, but I think there's a big difference between being in the jail interview and being in open court. By the way, keep in mind, it's not just being in open court singularly. I think you have to look at the fact of you're in open court with the accuser in this case. So I think there's different presumptions. I think you can't just ignore that facet of this that...
Let me just make sure I understand the distinctions you're making, because you're saying if you're at a police department in custody in jail garb and you do an interview, or if you're at the jail and it's on a video and you're in jail garb, that's okay.
Yes.
But if you're in open court for a brief or relatively brief court proceeding, that's not okay.
Well, I think in this scenario, it's not okay. I mean, you could paint strokes where, what type of case is it too? I mean, I don't want to go diving in the weeds, but you have to remember, this is a CSC case and the victim is there. You're not going to see her in open court. So to ignore that facet.
I'm intrigued by what you're saying. And by the way, I feel very strongly that defendants need to be in civilian clothes as the U.S. Supreme Court has required. And as a trial judge, I always, of course, adhere to and think that's a very important for the presumption of innocence, but I've just never seen it extended this far. So why is it the fact that the defendant is testifying in court, the victim is testifying in court in front of the defendant, why does that change the dynamic? Doesn't that help the jury? This poor woman is now deceased, the victim. This is the jury's only chance to observe her demeanor while she's testifying and to see how she faces the defendant at counsel's table. I would have thought that dynamic cut in exactly 180 degrees in the opposite direction.
Well,
That it's much more probative under the 403 analysis than it is prejudicial.
Well, I think it's certainly highly probative. I'm not going to sit here and tell the court and say that it's not highly probative. I think it certainly is highly probative.
Now your issue in the case is going to be credibility, right?
Absolutely.
A person who's now deceased.
Oh, no, I agree with
Jury's
you.
only attempt to evaluate her credibility on the stand.
I think you're correct. I would say...
Counsel, can I ask, and this I think sort of goes to that, did the trial court look at this video?
You mean the circuit court?
I'm sorry, yeah.
Okay, I wanted to make sure, if we're talking you mean the circuit court?
Right, because the way I read I mean, the court specifically said, I haven't seen it. I understand that a written transcript of the proceeding was submitted, and I see on the transcript that the counsel said, I've submitted it. I mean, we have it. The trial court said, I haven't seen it, and I'm wondering how we can review as an appellate court the correctness of a trial court viewing both the probative value of the victim's testimony and the prejudicial effect of the jail garb. And at one point, he's actually handcuffed also on the video at the end before he's escorted out. How do you evaluate the probative and prejudicial value if you haven't seen the video?
Well, at this point, I can't recall, but if the court certainly said that on the record that they didn't see it, I think it's problematic. I don't think that certainly cuts against our argument, but I mean, I think you have to review the record and sort of make your own decision. Why? I think it would be problematic that if the court in fact didn't review the record, I think it's certainly troubling to make that decision.
We and the Court of Appeals were asked to review the proprietary, the correctness of the trial court's determination under 403, I guess also under due process. And can we do that if the trial court didn't actually view the evidence before engaging in the analysis?
Well, I would say yes, for the simple reason that if the court didn't have the video here, then the court certainly couldn't do that. But I think the court could factor in, not to be disingenuous to the trial court, but if the trial court didn't even bother to look at the record, I don't think that should obfuscate this court of the duty to do it.
What if the video actually only showed your client once in jail garb, as
Right, but it
opposed to, but the trial court didn't look at it to see?
Well, then that's their malfeasance, and I think the court should certainly look at that respectfully, unkindly. If the court didn't do it, I can't, and you wouldn't expect me to, tell the court, again, the video was part of the record, we made it part of the record. If the court...
Is that a basis for remanding it to the trial court to actually do that part as part of the analysis?
That's a fair question. I guess I don't want to jump to an answer, but certainly the court, I don't know if the court, sua sponte, could just review it on their own and formulate their opinion and then give the court guidance on, in the future, we've looked at it, we think it's fine, we don't think it's fine. I still think it gives the court appellate review because it's part of the record. But I mean, I'll defer to the court on that. I don't want to say it's appropriate. I don't think it's inappropriate, but I don't want to say I'm asking the court to do that. I guess I wasn't prepared to address that particular facet. I don't think the court is wrong. There's certainly, and for the record, obviously, you're aware that obviously the defendant was shown dozens of times. Not that the court is quibbling and saying it was there, but...
This was a long hearing. It was like 2
Yeah, it was a couple
hours.
hours. Yeah, I think it was about a 2-hour prelim, so it wasn't short or brief. It was 2 hours.
And from my, which is ironic because you have a blind judge who's doing an analysis of this, which is great, but that's why I have an excellent team of people that work with me. But it's interesting because from what it was explained to me, the camera seemed to flash to the defendant quite often.
And the reason being, and just to be fair, that wasn't done for effect or anything else. It was what happened, and I think it was the defense attorney at the time, which wasn't us, was clicking his pen, and it was sound activated.
I see.
So to be fair, I don't want to give you a thing this was somehow rigged to focus on. It wasn't. It was sound activated. One thing I want to mention, because I know my time may be limited, I'm happy to answer questions. I think the question becomes is, well, how do you view the prejudice, if you will, in this scenario? Because you're going to be, well, that's the whole point. We have to subliminally figure out, is a juror going to be influenced? I asked the question, I thought about this morning. Let's pretend I'm going to cross-examine. Let's say the victim, the accuser victim was there, and I'm going to cross-examine the inconsistent statement with this transcript, and you're part of my firm, and I asked you, I'm going to impeach with the inconsistent statement. The first thing you would say to me is, don't show the video to the jury in your impeachment. Use the audio. They're going to see your guy in jail garb. If not, you better get ready for an ineffective assistance counsel claim. I would not show that video if I was cross-examining. Would I use the audio? You bet I would. Would I potentially use the transcript? You bet 100%. But I don't think anybody here, if they were on the defense side, could imagine the scenario. Respectfully, impeach with the video, because you could show, her demeanor at the prelim if it's inconsistent with
It's a bit
this.
of a red herring, isn't it? The question isn't whether it is prejudicial to your client or has some degree of prejudice. The question is whether, under the court rule at least, whether that prejudice is substantially outweighed by its probative value. And here you've already acknowledged it's highly probative. So I'm not really sure why you're going into whether you would offer a video of your
Well-
client in jail garb should matter at all to the analysis today.
Well, just because it's highly probative, to suggest here any insinuation that the defendant could be construed dangerous or guilty in this scenario is, I don't care how highly probative it is. I think the overriding concern here, and you're analyzing this, should be, well, the video is highly probative. It's tragic that the accuser is deceased. It is tragic, and I'm not making light of that. But we're going to say, based on that, if a juror, by the way, subconsciously, and that's what's funny, they mention that the juror may not even be aware of what their thought process is. They say
Well, that all
that.
goes to the hundreds of cases that are out there on jail garb, on the pretrial issues or interviews. That argument can be made in every one of those cases, and every one of those cases at the federal level and at every other state has gone against your argument. So what makes this case different? You started at the beginning telling us, I think because it's a preliminary exam or because it was in court. But otherwise, everything you've said today applies to every one of those cases that comes out the other way, doesn't it?
No, because I think, first of all, none of those cases, the defendant is actually in open court. Obviously, Your Honor, I know you were a circuit court judge. I practiced in front of you. I think it's a lot different environment when a juror sees somebody in a jail setting, obviously having common sense, knowing, well, he's in jail, he's being detained, he's being questioned. The insinuation, in my opinion, is if you're in a court of law and you're still, let's say, either shackled or you're there, you're dangerous. It's different. It's a completely, and by the way, none of the cases say that. They don't address that. They don't advance that. This is a singular thing. Then you have to couple with the fact that I think it is different on the prejudicial value when not only is he in court in that scenario before a neutral detached magistrate, which I think is absolutely different than being in a jail interview. They are absolutely severable situations as far as how a juror would construe it. And then number two, you're going back and forth between the accuser and him. That increases the prejudice. Now, in my opinion, obviously, I respect and I've read the amicus brief, I absolutely respect victims' rights, but I can tell you, obviously, I respect the defendant's rights too, where, first of all, he's not going to get a chance to cross-examine anybody here. He's stuck with that record, and in my opinion, obviously, we all feel good about letting the video in. It's a good feeling, but here's the question.
I don't know that anything about this case makes me feel good, but
Well, I don't.
you just said something that's not exactly accurate. Your client did have a chance to cross-examine this counsel at the preliminary examination, or else this wouldn't be admissible, I don't think.
It's admissible, but we understand, obviously you're an experienced jurist, you understand the cross-examination, at least the level of cross-examination. Typically, the prelim is much different.
Far from ideal on for all the reasons you said, and I'm very sensitive to all those points. If it could be avoided, it should be avoided. There's no question. But it can't be avoided in this case. So, I'm left here thinking if the victim did a terrible job on the stand and looked terrible, maybe you would say we should play the video. So does it depend on how well she did? If she comes across well, you can't play the video, and if she didn't come across well, you can? Or what is the argument here?
Well, I think the argument here, number one, is obviously that this is a question of whether I want to play the video or not in the case doesn't change the fact that the case law indicates there can't be any insinuations, implications, or anything suggesting guilt. My bar, in my opinion, frankly, at least on the due process, is you should err on the side of caution respectfully that if you think a juror could be tainted consciously or subconsciously, as difficult as the decision may be, I think it errs in the side of the defendant in due process. That's what the rules are set up for. It may provide a difficult decision that the prosecution gets deprived of the ability to play what they believe to be a favorable piece of evidence. I concede the fact. I understand why you would want to play the video. I'm not going to sit here and try to downplay, obviously, the value of that. The value is significant. To argue, you have no credibility if I argue otherwise. But also to ignore, well, the defendant's rights in this particular case, that a juror could be improperly tainted by it. And you say, well, it's different than a trial. I can tell you it's a lot closer on that side, this scenario, on the right.
So I asked you at the beginning if you were asking us to adopt a bright line rule, and you
No.
said no, but it sounds closer to that, that if it's in court, if the jail garb is viewed in a court proceeding, then it's a violation of due process.
I think in this case, what concerns me is not only that it's in court. That is a facet of it. Absolutely. I think the other facets of it, and I'm not sure that, and the court can certainly, again, obviously you can look at it under 4 or 3 or due process. I don't think it's a bright line rule in this case. I think the fact that they're in court, I think also the frequency here makes a difference of how many times that it pans back and forth. I think that's a factor too. So I think it's very fact specific.
So if it was just at the beginning of the proceeding and at the end of the proceeding, that would have been fine.
I think certainly the prejudice is less on the particular juror. Also, you facet the fact of how much these Zoom is used today. It's much more, as I said, commonplace. Yeah, I think everything has to be a fact based on this record. I think this is somewhat fact specific. Again, the court could certainly give guidance on, like they do on other rules, like character evidence. You have to apply some type of rule to look what's going to make it where it becomes unfair and a due process violation. I don't say there's a bright line rule. If the person's in court, that's it. They have to be brought before civilian clothes. I'm not asking the court to adopt something like that. I think that's frankly problematic. Although, let's be fair, to change the person in civilian clothes if you're going to use it in front of a juror is not technically that problematic. This has happened. It shows you there's no cases here in this scenario because it hasn't happened very often.
When should the objection have been made to be timely under Shaw or Estelle? Should it have been made at the prelim?
No, because number one, it doesn't give rise till they're going to use the video. But so we're clear, and I know there was some back and forth in the briefs on this particular issue, and I wasn't going to comment on unless it was asked. First of all, there was the discussion that I argued, and I offered to bring the witness in, that there was a request. Now, I read the prosecution's brief that there was no request made, but just so you know, on this particular issue, one, I think the objection becomes timely when they offer to use the video at trial. Obviously, that didn't come into play until the victim's untimely death that they offered. I wasn't even aware it was videotaped, by the way. Now, again, I wasn't the attorney. Obviously, it's unusual that until it was offered, I immediately objected to it, by the way. I objected to release of the video. I'm not going to, that the video shouldn't even have been released. But, so that was objected to. But to preemptively say, well, at the prelim, he should have been in civilian clothes, and you waived the timely, you waived it by not doing it. First of all, I did indicate, and I made an offer of proof for this record, that, and I offered to call the attorney, that he did actually make that request. And by the way, and again, it's cited in the record, my colleague here said when I made that argument, I have no reason to doubt Mr. Grable. I offered to call the witness. Now, at that particular point, I think if you're going to argue that as a facet, I think I made my record. I think I preserved it, even if I followed your directive that it should have been argued at the prelim. But I don't think I think it was still a timely objection. But I believe the attorney did, and I made the record to suggest that.
Okay, thank you.
Other than that,
Your time is up.
Thank you. I appreciate the court's time. Thank you again.
Again? Okay, I wasn't sure if I was allowed to just start. Jillian Seiler, P77564, prosecution for the appellee for the people. So essentially, a trial is a search for the truth. The defense has argued that it's a violation of due process for the defendant to appear in a video depicted in jail garb. This argument was premised on People v. Shaw and People v. Estelle, neither of which cases actually reversed the defendant's conviction after they sat through the entirety of their trial in jail garb, because neither one brought the objection in a timely manner to the court. Just as the defendant in this case did not object to sitting through the preliminary examination in jail garb. And absent the objection, it's impossible for a court to take it up, that they can't possibly make a ruling on it. And in fact, in Estelle, the defendant had told the guard that he wanted to wear street clothes prior to being brought before the veneer of the jury. But because it was never communicated to the court, the fact that he had talked to a jail guard was not considered in any way bringing it to the court's attention. It's not possible at this point for us to take testimony of the victim without the defendant being in jail guard because of the fact that she is deceased. So we are now left with having to work with the video evidence, and since the beginning of this case, the defendant has asked that this entire video be stricken from the record, not be allowed to be brought in. Defense has put forth that perhaps we could do audio or have a transcript read, but that in no way allows the jury to actually assess the credibility of the victim as she testifies. Importantly, all the way up through the relief requested by this court, defense counsel is still asking that the video be suppressed. At no point has he ever made the somewhat more reasonable request that the defendant simply be redacted out of the video. That, for example, a black box be placed over top of the defendant, or that the screen be essentially moved so that the defendant is not visible. We have never had an opportunity to argue that. It has never been brought up at any point. Instead, he's asking this court to grant a sweeping new
Counsel, would
constitutional
that be something
protection.
you'd be okay with? Like, if this was to go back to the trial court to kind of figure out if there was a way to kind of resolve this in a creative fashion, would that be something that the people would object to, or would you be okay with that?
Following the motion hearing in circuit court, I had a phone call with defense counsel in which I indicated that that was an option that we would take. But
So you would be okay with this going back to the trial court and then trying to work things out of the trial court as to an amenable kind of like resolution to this matter?
absolutely.
Okay.
That's
You're
actually,
saying you've offered that?
I did.
Okay.
That was in a conversation that we had after the circuit court ruling, but before the application for leave to appeal was filed.
Counsel, is it your understanding that the trial court watched the video?
No, I'm sure Judge Lambros did not watch the video. I think he indicated that he was relying on our written briefs and our oral arguments, because both parties did.
So in evaluating the probative value of her testimony and the prejudicial effect of how often and how he was shown in jail garb, and as I point out at the end, he's actually handcuffed at one point as well, how do we as an appellate court review a trial court's 403 determination when they didn't look at the evidence?
So to address the handcuff thing first, the video itself that this court was provided is the entirety of the preliminary examination. Under no circumstances would we ever seek to admit the entirety of the preliminary examination. It's the testimony of multiple witnesses. There was a motion to recuse that was in there. There was a bind-over motion. All of that is not actually admissible, and we'd never move for that. The portion that we would ask to admit is 58 minutes and 20 seconds long. It's the point from where the victim takes the stand until she is excused from testimony. The defendant is never in handcuffs at any point during any of that. As to how the court could do a 403 analysis, I think that the court looked at the written and oral arguments on that, which was that defense counsel indicated that the defendant was viewed in jail garb, I think 30 to 40 times, sitting next to his attorney. We briefed that every time that there was a noise or something.
But the point is maybe, and so maybe the prejudice could be presumed, but the probative value of how necessary it was that you had video of her testimony. If you didn't watch the testimony, how can you as a trial judge evaluate that it is in fact that probative, that it outweighs the prejudice that maybe you're presuming?
And I think that it would have been ideal had the trial court judge watched the video ahead of time. He received it in, I believe, a Dropbox link and relied instead on our representations. And I believe both parties were representing that the victim testified in the manner that she testified, and the court was essentially relying on our representations that it was probative. And I think that both parties had indicated that there was a great probative value. I agree. I think that it would have been ideal had the circuit court judge actually reviewed the video ahead of time.
He said she may be incredible. I don't know. I haven't seen it. She may be incredible. She may not be.
Right?
How is that an informed analysis of the probative value that outweighs the prejudicial effect?
Well, what I can say is that this court has had an opportunity to review it, and so I think that the probative value is absolutely in that video and that you can see exactly how it is she testifies. As to whether or not the court should have ruled without watching the video or whether he could make a thorough evaluation of how probative it is and how prejudicial it is without watching that. I think that it would have been better had he watched it.
So a reviewing court, we can substitute our opinion.
I'm sorry?
I mean, so as a reviewing appellate court, as the Court of Appeals did too, who said the trial court went through the 403 analysis and found that it was more probative than prejudicial, we're substituting our judgment for the trial court's evidentiary decision.
Well, the trial court's evidentiary decision was based on the representation of the parties rather than actually watching the video.
Okay.
It would have been better and stronger had
Was
you
there a
watched the video.
dispute amongst the parties about what was shown in the video?
No.
Such that the judge would have needed to watch an hour-long video to determine these questions?
There isn't. We've agreed that the video pans to the defendant 30 to 40 times and that he's in jail garb. We agree that it's
And
the
is it
victim testimony.
is it really a gigantic leap that the victim's testimony on a CSC1 charge would have probative value, significant probative value in a rape case? Or is that, I mean, that's something that's really at issue in this case? Is your opposing counsel claiming her testimony is not probative?
I don't think so. I think that there's been essentially stipulations throughout the entirety of this case that the testimony is extremely probative, that
Well,
that
but
is.
the question is not her testimony, it's her video testimony as opposed to audio or transcript of her testimony, right? There's no question her testimony is probative. The question is, does it have to be on video?
So there have been arguments, and it's been briefed as well, some of the different mannerisms and gestures that the victim made during the video. For example, at one point when she is asked, I believe on cross-examination, how it is that she went from being sexually assaulted on the ground to up in an upright position, she actually physically demonstrates for the jury her arm being lifted and her being lifted up onto her knees so that the sexual assault can be finished. So those types of evidence have made it into the court, and it's never been disputed that this is what happened or that the video is incredibly probative.
Anybody disputing that observing the demeanor of the witness while they testified is important to credibility, a credibility assessment by the jury? Is anybody taking that position in this lawsuit?
No. Again, both parties are entirely in agreement on all of these facts. It's just a question of whether or not Estelle and Shaw should be extended to video testimony or video evidence.
Was
or
I
if
being
it's only.
hyperbolic? Is there any case anywhere that supports the defendant's position?
I have not found a case that actually supports the position. The Supreme Court of Kentucky came closest in supporting the position in that they're essentially, I had indicated, would be a bit more of a strict 403 balancing test where the state would have to show that there was an interest.
But even they remanded, suggesting that the video could be admissible if it met certain criteria.
Right. Yes, in that case, their issue was that this, the trial court refused to give any sort of jury instruction at all and wouldn't take up the issue. So I don't think that we've ever had a question as to whether or not whether or not it's incredibly probative. And I would note, actually, there was a case out of Florida that followed the one that defense counsel had brought up, and that's the case of Burton. And they had a statement in there that I think really applies, which is that our adversarial system isn't a test of competing affidavits because a critical part of the jury's decision-making process is watching, as well as listening for cues to decide which evidence and testimony is reliable and credible and which is not. And so essentially every court that has dealt with this, where there's a video evidence of a defendant who is in jail garb at the time that the evidence is collected, whether it's an interview or in a court case, which is what the Thompson court is, that was actually at an arraignment, have all looked at this and determined that 403 is the appropriate means of testing how we go forward. Because every piece of evidence that comes in is assessed for its probative value and its prejudicial value. And in this case, the court determined that the probative value was outweighed by the prejudicial value. Was not outweighed by the prejudicial value. And I think that it's important, too, to bear in mind that what we're looking at is the video as a whole. It's not just a portion of the video. So as we look at the entirety of the testimony of the victim in this case, that is extremely, extremely probative. And
Is it an argument that it's maybe just premature, right? I mean, in some of the responses that you've given, that maybe there are ways to, alter the video or cover it or change frames or whatever. And, we're not showing the whole thing and all of this. And so, I mean, this is all in an interlocutory posture, right? So we don't have, it sounds to me like there's a lot of decisions still left to be made about how, in fact, this video is going to be shown if we uphold the trial court's decision. Is that correct?
That's absolutely accurate. If this case goes back to the trial court and is postured for trial, and if the Court of Appeals opinion is upheld or this court says that we are not going to take this up at this time and we go back to trial, and defense brings a motion to have the defendant redacted out of the video, then we would have that 403 analysis on that exact question. That was never brought up and we've never had an opportunity to litigate it. I have been answering the question for the past 2 years as to whether the entirety of this video should be kept out. And that's where the 403 analysis comes in, and it says that this is incredibly probative. If we change that analysis to should the defendant appear in jail garb during this, or should a black box be placed over top of him, should the video be changed, should artificial intelligence be used to change his clothing, I don't know that that's possible. But if the question were changed to something like that, now we're in a completely different 403 analysis. But we've never had that.
So, counsel, I guess my question is that, and I'll ask brother counsel, even though his time's expired, but if there was a phone call made that you guys wanted to see if there was a way that you could work this out, I guess my question would be, why can't we just allow you guys to go back down to the trial court and see if you can work it out?
I would love if you would allow that. That's exactly what I want to do.
Okay.
And also, it goes to the very basis of why we are here today. We are here to keep the victim's testimony from getting to the jury so that the jury can see her. That's the point of this appeal. And I'm asking this court not to do this. Because if the question were just about jail garb, there's a dozen different ways to handle that. But at all times over the past 2 years, every motion and every appeal has been with the aim of keeping the victim's testimony from the jury. That's why we're here on this question, and I'm going to ask that this court deny the appeal because I don't think that that's the best way to handle this, and I certainly don't think that an extension of Estelle and Shaw to all video evidence is warranted in any way, shape, or form. And with that, if the court has any other questions, otherwise I guess I would yield any other time.
Don't see any. Thank you very much.
Thank you.
Chief, can I just ask defense counsel, I know he's...
One question?
Yeah.
One question.
Okay, get one question. Counsel, I'm just trying to understand, what is the main objection if the idea is to go and figure out a way to make this work? You had said in the beginning that, you were open to different ideas. What I'm trying to understand is, what would be the problem with having this go back down to the trial court and then see if you guys can work out a way to do this in a manner that would be equitable and fair to both sides?
Well, I think you ask a fair question. This particular reasoning obviously was actually addressed earlier. The prosecution in the earlier brief felt there was no way that they thought it was all or nothing proposition because it would be impractical that I understand technically you could black out when the defendant testified, but I still think you have a reason that if you do it 40 or 50 times, I think the jury still reaches the same inference that it doesn't make any sense. And the thing is that's interesting, the prosecution argued that position earlier when we were at the trial court level.
But the question to you is, that Justice Bernstein is asking
I'm
is,
sorry.
Are you open to that? Or are you opposed to a solution that would prevent the jury from seeing your client in jail garb during the preliminary exam?
I guess
If there was a way to do it, are you opposed to that?
If there was a practical way to do it that wouldn't leave the jury with an inference, because then the problem is they're wondering every time the defense attorney asks a question, he doesn't get seen or neither does the defendant. If there was a way to do it where it didn't look, where there were inferences be reached that the defendant must be in jail garb, that's why he's not being shown, I don't know if there's a practical way to do it, but assuming there was, I wouldn't be opposed to it if there was a practical way. I could tell you in the original pleadings, the prosecutor didn't think it was, but yes, I would be open to it if that could be accomplished,
Does that
to be
answer your
fair.
question?
Thank
That
you
was
so
a
much.
long-winded answer for a relatively simple question. I
Thank you.
apologize.
Thank you both. The case will be
Thank you.
submitted.
Thank you.